Good afternoon, and thank you for joining us for our Landlord Focus webinar on eviction next steps. I'm going to wait just a moment to see if anybody is going to join our webinar before I get started. So thank you for your patience. All right, in just another moment before we go ahead and get started. All right, let's go ahead and start. Again, welcome. This is our afternoon landlord focus webinar on eviction next steps. And just before we get started, I wanted to give out a reminder that staff is not able to offer any legal advice, but we can offer facts, best practices, and an overview of the CSFRA and other state laws. All right, let's begin with some introductions. My name is Andrea Kennedy, and I work for the City of Mountain View's Rent Stabilization Program. And my colleague Joanne Pham will also be giving the presentation with me today. So you'll see her in just a little bit. We also have our program manager, Anki Van Dersen, who is available to answer questions. So let's go over how this webinar is going to work this afternoon. So Joanne and I will be giving the presentation, and you all as members of the public can use the Q&A icon, or you can use the raise hand function, or if you're joining us over the phone, you can dial *9 to ask your questions, and city staff will answer questions at the end of each section during our question break, or at the end of the webinar, we will have open Q&A time. Also, since we are on Zoom, I did want to mention if the internet goes out or if we have some interruption that shuts down the Zoom, please just log back on using the same link and we'll pick up where we left off. All right, so this will be the indication for any questions that you might have. You can use the Q&A, the raise hands, or *9. And I also wanted to mention, if you look in the bottom right, that is our contact information there, so you can write that down. All right, and our agenda for this afternoon, we'll talk a little bit about the eviction moratorium. We'll go into the eviction process in California, and we'll talk about Mountain View's housing and Eviction Prevention Center. All right, so let's get started talking about the eviction moratorium. All right, so the state eviction moratorium, or AB 2179, we have the link to the bill's text in this PowerPoint, which you will be getting emailed a copy of. So if you're interested in reading that, you can go ahead and use this link here. So this is an extension of AB 832, which was our COVID-19 Rental Housing Recovery Act, and it extends tenant protections through June 30th of this year for non-payment of rent that was accrued between October 2021 and March 2022, when in the case that a tenant has a pending rent assistance application, and that rent application had to be submitted before the deadline of March 31st, 2021. So just at the end of last month. And the idea here is to sort of give the state time to go through the applications, qualify the tenants, and pay out those funds, okay? So we'd like to keep that in mind. And also landlords will be able to evict tenants without restrictions for non-payment of rent starting April, so starting this month, moving forward. All right, so there were 3 different stages under the eviction moratorium. So the first one, and we'll talk about each one of these a little bit more in detail. The first one is called the protected time period. So this was March 2020 through August 30th, 2020. The second time period is called the transition time period, and that is from September 2020 through September 30, 2021. And the time we're in right now, the recovery time period, started October 2021 and goes through June 30, 2022. All right, so that first time period from March 2020 to August 30, 2020, tenants cannot be evicted for non-payment of rent if they returned their COVID-19 hardship declaration form within 15 days of receiving their notice to pay rent or quit from the landlord. So the landlord would have served the notice and the tenant could return this hardship declaration form. If the tenant did those steps, they cannot be evicted for not paying rent during this time period. That's important to remember. Okay, our second time period, which goes from September 1, 2020 to September 30, 2021. The tenants cannot ever be evicted for not paying rent if they did 2 things. So first, they had to, again, return that hardship declaration form back to the landlord within 15 business days. And they also had to pay 25% of the rent due between that September 1, 2020 and September 30, 2021 date by September 30, 2021. Okay, so if they did those 2 things, they cannot be evicted for not paying rent during this time. The rent is still owed, but they cannot be evicted for it. And Joanne will talk a little bit more about what you can do to get that, or to recover that rent. All right, so now we'll talk about our recovery time period that we're in now. So this would be October 1, 2021 to June 30, 2022. And the tenant's eviction will be on hold if the tenant had applied for rent relief through the state's rent relief program. So that will be through March 31st of 2022. If they have a pending application, we're going to have to wait, and that eviction will be on hold. All right, so I know this is a lot of dates, but we are going to give you a copy of this PowerPoint. So let's talk now about what happens on April 1st, 2022 going forward. So again, we want to remember that the eviction is on hold if the tenant has applied for that state rent relief for rent up to March 31st, 2022, and their application is pending. However, rent going forward, so April, May, June rent, that needs to be paid by the tenant, even if they still have a pending rent relief application. So any rent starting April 1 is going to be due on its normal due date. All right, so let's talk about UD filing. So before you, the landlord or the property manager, is able to file the UD summons, you have to certify one of the following things. So one, that the landlord had applied for rent assistance and the tenant was denied, that the landlord applied for rent assistance and the tenant hadn't responded to the landlord's application in 20 days from the date that they received their 3-day notice to pay rent or quit. Number 3, the rent demanded is from a new tenancy. So that's a tenancy that started after September 30, 2021. Right, and then the last thing, the landlord files a statement that a determination is not pending on a rent assistance application filed prior to April 1, 2022. So you really want to just be able to show that you made an attempt to get rent assistance if that was possible for your tenant, okay? Okay, so now we'll look at notice requirements before April 1st. So a notice for rent due between October 1, 2021 and March 31st, 2022 must include at least a 3-day notice to pay or quit. It should also include the amount demanded on each date it becomes due. So you want to show specifically April, or let's say, for example, January, X amount is due, February, X amount is due, March, X amount is due, and really spell it out very clearly. Okay, and you also want to include the phone number and website for rent assistance when that was possible. Okay, so now we're going to look at noticing requirements after the April 1 date. So a notice for rent that is due between October 1, 2021 and March 31st, 2022 must include specific language. So you have to have the specific language included in your notice if you're giving a notice after April 1 for rent due between this time period. Okay, and so these notices must also include 5 things. So you want to include the 3 days notice. Of course, this excludes Saturdays, Sundays, and any judicial holidays. We always want this to be in writing and requiring our rent payment. Again, we want to show the amount that is due very specifically, spelled out very clearly for the tenants. We want to include the name, telephone number, and address of the person whom the rent payment shall be made to, and if the payment may be made personally. So I know a lot of the notices that I see at the end, they have a pay to section, and it has all that information listed there. So if you don't have that in your notices, you want to be sure to include that. And also to include the usual days and hours that that person will be available to accept that payment. And then another thing that I always like to mention during these webinars is for rental units that are covered under the local rent stabilization law, the Community Stabilization and Fair Rent Act, we are required to submit a copy of that notice to the Rental Housing Committee within 3 days of serving that on your tenant. So if you know that you are serving a notice on a covered unit, you want to be sure, 1, that your property is registered online, and 2, that you can log into your account and upload your termination notice. All right, and the other thing to mention is you also must upload a copy of any what we call termination notice follow-up documents. So if you serve a UD, or if you have a tenant who received a termination notice or a UD paperwork and they just up and moved out, you have to let the rental housing committee know within 7 days of either serving that paperwork or within 7 days of the tenant moving out. And again, you can do that on the website, which is mvrent.mountainview.gov. If you have any questions about registering, which is required, or uploading any of these notices, I'd be more than happy to explain how that's all done. Okay, so I think I have one more here. And again, of course, constructive evictions are not allowed. So constructive evictions include things like changing the locks, cutting off utilities, harassment, preventing the occupants from entering the unit, or if there's any unaddressed habitability issues that would force someone to move or make it so inhabitable or have them so unable to live in the unit that they would have to move. So the only way to do an eviction is to go through the process that Joanne is going to explain next, by serving the UD and going through the courts. Okay, so we'll just pause here for a second to see if we have any questions. And again, you can type that in the Q&A. You can use the chat, or if you prefer, you can just go ahead and raise your hand. I will be very transparent. We only have you on the call, the one person here. So if you have any questions for us, we are here to answer those for you. All right, we'll just go ahead and let Joanne bring her slides up before we get started again. All right, thanks, Joanne.
Hi, everyone. So we're going to briefly cover the small claims process following the the recovery period that's going on right now. So tenants cannot be evicted in unlawful detainer court for past due rent accrued between March 1st, 2020 and September 30th, 2021, as long as the tenant sent in a declaration form and provided 25% of past due rent for the period of September 1st, 2020 through September 30th, 2021. So that means any past due rent that accrued between March 1st, 2020 and August 31st, 2020 is exempt from the eviction process in a sense. So starting November 1st, 2021, landlords can use the small claims process to collect any past due rent for these types of cases if they failed to follow the rules that were in place during the COVID recovery period. The small claims court process allows for landlords to request this rent back if they did try to obtain rent relief. So they have to show one of these three things. Either they made efforts to investigate the availability of rent assistance on the tenant's behalf, or they applied for rent assistance themselves, or they cooperated with the tenant's efforts to obtain rental assistance. The award for the actual small claims judgment might be reduced if the landlord refused the rent relief payment, or they refused to participate in the process and the tenant would have qualified. So let's briefly cover the eviction process generally in California. First, before the eviction process moves forward, a 3-day notice to pay rent or quit must be provided to the tenant. This gives the tenant 3 days to either pay the rent before a landlord can begin the eviction process in court and file an unlawful detainer action. So this is a quick overview of what that eviction process would look like. First, after providing the eviction notice to the tenant, the 3 days will have passed, and then the landlord can file a summons and complaint in Superior Court. And if the tenant fails to respond within 5 court days, then there would be essentially no answer, and the landlord can file a default judgment against that tenant. Therefore, the tenant would most likely lose that case, and then the sheriff would perform a lockout of the actual unit itself. If the tenant does provide an answer within 5 court days, a trial is set within 20 days. And depending on the outcome of the case, either if the tenant wins, they can remain in that unit. And then if the tenant loses, then again, it would proceed with the sheriff locking out the tenant from that unit. So after a court order, but before the actual lockout, the tenant does have one last opportunity to try and stay in that unit. This is what's called a relief from forfeiture. The court can reinstate the tenancy if the complaint is based on rental debt accumulated because of COVID-19 financial hardship, and the tenant applies for rent assistance and is approved for the full amount asked for in the notice. And the tenant must file this application before the sheriff actually completes the eviction with that lockout. At our City of Mountain View Housing and Eviction Prevention Center, we are back in person at the public library, and we can help with this eviction process if you have questions. However, we do not provide legal advice, so we would be referring you to legal resources, or we would be providing general guidance about the situation and can try to evaluate the case itself. We also have mediation services, and we can help with the rent relief process if your tenant is still waiting for their rent relief application to be processed. We're located at 585 Franklin Street in the first floor program room, Mountain View, California, 94041. For the remainder of April, we are operating Thursdays only from 1 p.m. to 5 p.m. And we are accepting walk-ins only, so there are no appointments. If you are not able to attend in person, we also assist by phone or virtually, and you can go to our Zoom room, our Zoom meeting in place of walking in person by visiting www.mountainview.gov/eviction help clinics. And you don't have to register. You can just click that link and it'll take you right into the room. Beginning in May, our Housing and Eviction Help Center will be open on the 1st and 3rd Thursdays only from 1 to 5 p.m. So we'll be there on May 5th and May 19th. So I can take a quick pause here to see if anyone has any questions on what we covered so far. Okay, so I see a question in the chat. It says, what happens after the June 2022 moratorium if the tenant does not pay past due rent, but pays rent on April and onward? The quick answer to that is the process would still be the same general process of a 3-day notice to pay or quit. However, I'm not sure what other local actions might take place following the June 2022 moratorium ending on that statewide basis. Andrea and Anki, if you have any additional comments, please feel free to chime in.
Yeah, I think that's generally right. The process would be the same, and you would work through the 3-day notice, and after that the UD process. If you're interested in staying up to date, as Joanne mentioned, a lot of things change very quickly, as I'm sure you're aware of. We can add you to our emailing list, and if there's any updates in the laws or any new actions that you need to be aware of, we can add you to that list and you would get a notification. Yes, okay, perfect. So we have your email address that you registered with. So we'll go ahead and add you to our update mailing list. Thank you.
Thanks so much for your question. Okay, we'll move forward now to our resources. So at the City of Mountain View, we have our rent stabilization main website, which is at mountainview.gov/rent stabilization. And then we have numerous COVID-19 housing relief resources available online at mountainview.gov/COVID-19 housing relief. These include our Eviction Help Center, emergency rental assistance, mediation for landlords and tenants, temporary rent reductions, affordable housing, and other COVID-19 relief programs. So as we briefly covered before, landlords must register their CSFRA covered properties and units and submit required noticing online at mvrent.mountainview.gov. If you do not register your properties or submit the required noticing online, there may be a defense for the tenants against the unlawful detainer actions and unlawful rent increases. So as shown in the screenshot here, the buttons on the right can be used to edit an existing registered property, to upload termination notices, banked rent increase notices, tenant buyout agreement forms, and any other required notices, such as the termination follow-up notices. And coming up for the remainder of this month, we do have additional webinars that landlords may be interested in, including on April 26th at 3 p.m., the mobile home registration webinar that's landlord focused. And then on April 28th, we have a stakeholder meeting for the annual general adjustment and concessions beginning at 10:30 a.m. and that is landlord focused as well. On May 10th, we also have another mobile home registration webinar at 3 p.m. And then on May 11th, we have a CSFRA landlord registration webinar at 3 p.m. Let us know if you have any questions about what those are. And then finally, we highly recommend visiting the U.S. Housing and Urban Development site for a lot of these useful tools for avoiding evictions during this difficult time, which can be found at www.hudexchange.info. Some of the options that can be used in place of evictions include deferring or reducing payments of past due rent, deferring or reducing future payments until the tenant's income increases, and applying a security deposit to the unpaid rent with the tenant's written permission, whatever is allowable by law. And then finally, if you are in need of legal assistance, landlords can contact the Santa Clara County Bar Association's lawyer referral service at 408-971-6822, or you can visit www.sccba.com. And you can also attend the Santa Clara County Superior Court Self-Help Center at the Family Justice Center located in downtown San Jose. And they're at 201 North First Street. Their hours of operation are Monday through Friday from 8:30 a.m. to 1:30 p.m. Except for Fridays, they close at 12. But they can be reached by phone on Mondays, Tuesdays, and Thursdays from 8:30 a.m. to 1:30 p.m. And they can be reached at 408-882-2926, selecting option 3. And that is the end of our presentation.
All right, perfect. So if you have any other questions for us, we're here, we'll hang on. You can type it in the Q&A or the chat or raise your hand. If you don't, please be sure to write down our email and phone number and reach out to us if you have any specific questions that you're going through. And we just want to thank you for coming and getting the information. And we hope that you have a great rest of the week. And please expect to see a follow-up email with this PowerPoint.
You're welcome. Thank you.
All right, thanks, Joanne. Bye.